Good morning, everyone. Welcome to our Zoom Q&A for January 29th, 2025. My name is Fatima Berkey. I'm a collections attorney, and Ken is co-hosting with me today. We always start out with our housekeeping items, so please remember that we are here to give general legal information. This is not an opportunity for specific legal advice. If you are looking for specific legal advice, please contact your association attorney. Also keep in mind that the chat function during the Zoom is intended for questions or requests for clarification and commentary in the chat. So this is, again, not to be interpreted as legal advice. Wanted to mention that we are still getting a lot of questions about the CTA. The U.S. Supreme Court in one case is requiring reporting. A second case has not yet been specifically addressed, but the lower court judge may revise the opinion. We are trying to keep up to date with all of this on behalf of our clients. If you have specific questions about this, please contact your association attorney. I know it's been a lot of back and forth. Finally, let's see. I guess that's all. I think that's all. Did you want to add into the Monday morning minute there, Chelsea, for those who want to look at that? Okay, so we're going to start with, instead of our first question, we've decided to, since I'm a collection attorney, we have three collection attorneys in the office, that we are going to do some mini tutorials as part of our Q&As when we have the opportunity, just to go over some specifics that we often see as collection attorneys when we are taking new matters under review. So one of the things that, the place to start would be when do you know that it's time to send a file over to your collection attorney? What does the attorney need? And what are you to do to make sure that you have what we need? So the first thing is a basic recommendation. Before you send a file over to a collection attorney, make sure that you're familiar with your governing documents and what the procedures are already in place for your collection, for collections based on what your governing documents say. There are usually some specific procedures outlined. Perhaps you have a collection policy. If you don't, we recommend one. Rules and regulations, those types of things. Familiarize yourself with that so that when we come back to you, when we ask questions, you'll know what we're looking for. The first thing that we have to look at is when did the debt start? That is because there's a statute of limitations in effect for all community associations. Right now, that statute of limitations is 6 years for WUCIOA communities and 3 years for old and new act condominiums. So I'm sorry, 6 years also for HOAs. So know that if the debt has occurred outside of the statute of limitations, it is uncollectible. That is why we do recommend, obviously, that referrals come to us earlier, sooner than better. We typically have more success when a debt is at a lower amount. Owners are more receptive, more responsible about responding to a demand letter on the earlier side. And again, we do see collections referrals that are outside of the statute of limitations. We do have to eliminate those amounts from the ledger because we cannot collect upon those. Specifically, there's some information that we need to see when we open a new collection file. Some of those things are things that you already know, most likely, which would be an account ledger. So that would be your management ledger. We need to look at that, determine from the very beginning a zero balance. So the time when we have to look back to the beginning as to when the debt began to occur, and that would be when we have to start with a zero balance ledger. And then we need some specific things like the owner's name and address, their property address if it's different from where they live. Some of these properties the owners aren't living there. So where are the owners living? If you have two different addresses, we need both of those. Ideally, you'd have a phone number and an email address for the owner. Copies of correspondence that you have mailed to the owner, notices about their delinquency. any type of correspondence, we need to review that. We need that in our file. Anything relating to fines, we need to see warning notices, fine letters. All of that documentation is required. Another thing would be to look at any type of misconduct that occurred that the owner is responsible for, insurance claims that were unpaid, any type of notices that were mailed relating to that. We do need to see that you gave the owner notice and opportunity to be heard before we can add any type of fine to our ledger. The other thing that we really have to, I think this can become a sticking point, and especially with some of our self-managed associations, when you are drafting your budgets on an annual basis and ratifying them, we need to look at those budgets and determine that they were properly drafted and properly ratified in order to collect upon the assessment amounts that are in the budget. And this can be something that just isn't focused on. And we see a lot of associations that come to us who've never had any problems with collections. And once they get a collection account and they need us to look at that, we then look back at their budget and see that there are mistakes in place. So as a matter of good practice, it's best to make sure that your budgets are in compliance with the statute, with WUCIOA on an annual basis. In the event that a collection matter takes place, you'll be in a position to act quickly, as opposed to having us review your budget, ask you to revise it and re-ratify it in order for us to collect upon those assessment amounts that are in that budget. And this is all the procedural things that we do, but there's also some practical considerations. Before you send an owner to us for collections, perhaps have you exhausted all of your internal efforts without going to a collection attorney, paying us to do the work? Have you reached out to the owner? Have you made contact with them to communicate with them about the fact that they have this debt? Are there some issues with your payment portal? You'll want to make sure that all of those things have been looked at before from a practical standpoint. It's obviously cheaper and in the best interest of all parties to settle this amicably and sooner than having to send it to a collection attorney. Once it comes to us, all communication has to go through us. And once we send that demand letter to the owner, we request that the association have no further communication with the owner about that debt. Of course, they're still required to communicate with them about other matters, but when it comes to the debt itself, then that communication must go through us. So it's best to exhaust all of your internal options before you bring it to us. And once you bring it to us, we take over. We conduct the internal. We conduct the file review, and we look at all the amounts, and we look at all the data, and we figure out how exactly we're going to we create the ledger, we send the demand letter typically with the ledger. And we send the demand letter typically along with the lien and the ledger to the owner. And that's the beginning of that process. I think, and then, just to kind of wrap this up, once that collection process is underway, sometimes an owner reaches out on the early side and says, hey, I see what's happened here. I can't pay this all up front. We do encourage payment plans as long as the board is in agreement with them and they make sense to the board. Often we'll get an initial payment plan proposal from the owner. We will relay that to the board with recommendations for a counter offer that might be typically more aggressive than what the owner is offering up front. And we usually ask for some type of down payment upon agreement to bring that debt down immediately with a relatively significant amount, depending on the amount of debt that's owed. We also have other types of, depending on what your governing documents offer, we can look at different types of ways to encourage the owner to pay their debt before we get to the foreclosure. Some of those include acceleration of assessments. That's an option for certain associations that have that. provision in their governing documents. There's rent interception, utility termination available to certain associations. These are different ways to motivate an owner to pay their account balance with the association. So without getting into too many specifics, because obviously every file is different, that's the general process. That's generally the way that we look at a collection file. As soon as it's sent to us, these are the steps that we go through. And most of the questions that come up have to do with budget issues. And so again, without focusing on budget, this isn't a tutorial about budget. We do have a YouTube tutorial about that. Please make sure your budgets are properly drafted and ratified. That will save you a lot of time when it comes to collecting upon delinquent owners. Ken, did you have anything to add to that, or did you want to move on to question 2?
I'll add a couple things. One is regarding the statute of limitations and how you figure out whether or not a debt is too old. And that often will depend on how you apply the payments if there are intermittent payments over time. So we have some clients where the first delinquency was more than, say it's a condo more than 3 years old. And then they made payments in, the next 2 years, but they didn't pay it all off. So depending on how your governing documents are written, you may be able to apply the payments to the oldest debt on the ledger. And if you do that, you will salvage the statute of limitations because the oldest debt that has not been paid may still be within the statute of limitations. But there are some of the documents which were written, especially by one attorney who did a lot of collections amendments to declarations. He required that the application of payments follow a specific order, which included paying the lawyer's fees first. And what that meant is that you could not wipe out the oldest debts on or the earliest debts on the ledger with partial payments. And so it is a challenge sometimes to figure out whether or not you are past the statute of limitations on collections. And you may need some help from your attorney in figuring that out. And it will depend on the specific language in your declaration or CC&Rs. Okay. And that's why it's important to know what your CC&Rs say, because it will affect how you collect. A comment about how ukiah is going to affect collections as well. Under ukiah, as it has now been revised, before you can assess anything like fees for misconduct or the insurance deductible, you are required to provide notice and an opportunity to be heard to the owner. So there are a very large number of documents out there that say that you can assess the insurance deductible to the unit owner where the damage occurred. And ukiah allows that, but only if you've done notice and opportunity to be heard. And so as we move into ukiah for all, this is going to become more and more important. And we would also encourage you to start doing that now. And then the other thing I would offer is that, and you'll have to help me on this, Fatima, the reason not to have the board or the management company communicating directly with a debtor who is in an attorney's office is that the information that goes to the debtor needs to be in a form that they can make a single payment and be done. In other words, a payoff amount is usually the question. And we frequently see owners trying to trick managers and board members into accepting a smaller amount of money as payment in full because the board member or manager does not understand all of the charges which have been assessed to the owner. So if they get the initial demand letter and then call, the manager and try and pay off the amount before the fees related to a lien or related to the demand letter and the attorney's fees, they are going to be shorting the association anywhere between $500 and $1,000 on what expenses they should be paying.
That's correct. And if, for example, and this has happened before, we get the file for collections, we move forward with our intake process, we prepare the demand letter, prepare the lien, we send the demand letter, record the lien, we advise the client immediately upon receiving that referral that they are no longer to communicate with the owner about their debt, and they are to pause any activity on any type of online portals that give the owners access to the management ledger. Once we take that information once we take your management ledger and create our demand ledger, they are not the same. And that's exactly what Ken is saying. Your management ledger that the owner might be seeing doesn't include the demand fees, the lien recording fees, the lien release fees, any type of file closure, additional fees that are associated with a collection file. If we send that demand letter and that has one amount on it, and the association erroneously sends an invoice to the owner 2 weeks later, or the owner can still get into their portal and access their account ledger, management ledger, that is not an accurate reporting of exactly what's owed. And an owner could potentially say that if they receive that invoice in the mail after they received the demand, that is what is owed, and they could argue that successfully. And we've had to unfortunately explain that to clients. So it is very important that you understand that once that file comes to us for collections and you get that acknowledgement from us, you must not communicate with the owner about their debt, because you might end up shorted, exactly as Ken is saying. If the owner receives a conflicting invoice or amount after we've sent our demand letter.
All right. Well, if you've got other questions about collections, you can certainly send them in. We'll answer them next week. Otherwise, we will move on to other matters. So question 2 is, which entity is responsible for maintaining remodel approval requests, the owner or the management company? When an association has had 3 or 4 different property management companies over 12 or 15 years, the records of older original requests do not get forwarded. Isn't this a homeowner responsibility? So there's a couple of different answers. One is that the owner is not responsible for keeping records for the association. There is a statute now that requires that the association keep records that relate to any requests for design and architectural approval for a period of 7 years. So that's the statutory requirement now, and that's true under UKIOA. It is also true under the condominium and HOA statutes. So the association should be endeavoring to keep records. Now, whether you are hiring a management company to help you in keeping those records is sort of a different issue. But you can't, as an association or as a board, decide that the record keeping is the responsibility of an owner or the responsibility only of the management company, because it is by statute the association's responsibility. Now, there was an addition to the statutes that requires management companies to transfer records when the management company is changed by an association. And the most recent version of UKIOA, which was revised last year, states that electronic records have to be forwarded within 10 business days of request by the board or termination of contract. And I thought it said 21 days for other records, but I'm not seeing that in the actual statute here. So 6490-495 is the statute reference for UKIOA. And it was intended to try and make sure that management companies will transfer the old records of an association to the new association. I don't know how effective it will be because the enforcement mechanism is not there. And so if it's, as currently written, you'd have to file a lawsuit against your management company for failing to comply with the statute. But there is now a very specific timeline embedded in the statute for when associations are entitled to get their records. As we move more to electronic records, I would expect this to become less of a problem because it should be an easier thing to store and keep backups. So we're seeing some associations and management companies move entirely to electronic records, and those do fulfill the requirement to keep records under the statute. Did you want to add anything, Tima?
No, I don't think so. Not on that one.
Okay.
That covers it. The third question we have, an owner made an unauthorized unit modification more than 10 years ago that was detrimental to the building. Once the action was discovered, the owner was unable to finance the repair, i.e. replacement at the time. Therefore, the association paid the amount in order to restore. Fast forward, the owner is now selling. Can the association now, 10 years later, ask for reimbursement? The short answer to that question is no. And that goes back to what I mentioned earlier regarding the statute of limitations. Because, and to just review that one more time, for HOAs, the statute of limitations is 6 years. For WUCIOA is 6 years. For new act and old act condominiums, the statute of limitations is 3 years. So you're looking at an event that took place 10 years ago. There's no ledger that we can put that in under any of the statutes, under any of the communities. That caveat being, if there, and this was not mentioned in the question, but it's worth mentioning, if there was some type of contract made at that time that is, if there's a valid and enforceable contract between the association and the owner regarding payment of this amount, that would be something that is enforceable. Most likely, we'd have to take a look at it. So, that would be my caveat on that answer, unless you have some type of written and recorded agreement that shows that there wasn't a contract between the parties to settle this amount. Most likely we'd be able to enforce that. But otherwise, if in the absence of some type of side agreement, the answer is no. Ken, do you have any comment?
Well, I'll offer one other exception. Tima is right. There is no legal authority to collect the money, but you could ask. And I suppose it's possible that the seller could feel a moral obligation to repay the debt they could not pay 10 years earlier. I'd be sort of surprised if that happened, but you can ask for people to voluntarily make payments.
That's true.
Yeah, next question is, other than the association attorney, are there restrictions on inviting non-board members, including property managers, to an executive meeting of the board? What happens if the board is not in agreement regarding inviting non-board members to an executive meeting? So I'm going to start with the second one. What if they're not in agreement? Any time you go into an executive session, there is supposed to be a motion made and a vote by the board to go into executive session. So if the motion was made to include or exclude a particular person like the manager, then the board would vote. So you don't have to be all in agreement. The majority vote would carry as to whether or not that person was invited into the executive session or not. So the statute for ukiyo about executive sessions is 6490-445. That does not apply to condominiums at this time. The HOA statute is very similar. It requires that you start an executive session during an open meeting, that you have a motion made and passed by the board to go into executive session stating what the subject matter is of the executive session. And so if the subject matter relates to or involves information that the property manager has, or even an outside consultant or individual owner has, If it is otherwise appropriate to be done in an executive session, you could include as a sort of a factual support or an expert, the additional people. So if you were dealing with a collections matter or a dispute in executive session, then it may be appropriate for involved owners to be included in the executive session or part of the executive session to allow the information that they have to be provided to the board so the board can fulfill their duty of adequate inquiry and use of objective information. Tina, did you have anything you want to add on that?
No, I do not. Our next question is, one of the things we're working through is our pet policy, specifically our maximum dog weight rule, currently set at 35 pounds. We are exploring the possibility of allowing larger dogs, but requiring the AKC Canine Good Citizen certificates. So I think the question here, I want to first say I'm interpreting this question not to involve any type of emotional support animal. They are treated separately, and they're a protected class under federal law and state law. We have addressed the issue of emotional support animals in prior sessions, Q&As. You should be able to look that up. If you have specific questions about emotional support animals, please submit a question about that specifically. The short answer to the question is that, you know, the rules, if you are wanting to adopt different rules about your pet policy, and as long as your governing documents allow it, you may do so. You may create an updated rule and regulation regarding your pet policy. We generally don't recommend that you have different requirements for different size dogs. If you're going to have a rule about your pet policy, we recommend uniform requirements. So, you know, if you have a certain rule for dogs under 35 pounds and another rule for dogs that are 36 pounds, it can get a bit hairy because, you know, for a host of reasons. I mean, a dog could gain or lose weight. You could have a dog that's 35 pounds on Monday and 34 pounds on Friday. So, you know, I'm not suggesting that every owner is going to argue this way, but it's possible. So it's generally recommended that you adopt a uniform rule for all pets. And if you want to adopt this, you know, policy about canine good citizens, that's something that you would want to put in your rules and regulations and make that clear to your ownership, and before it would be enforceable. Just looking to see if I have any other comments. I don't think so. Ken, did you have more comments about that?
Not really. I just would offer that usually what you care about is the behavior and conduct of the dog. You don't care about its weight. And I'm not exactly sure why the weight has become some kind of an objective measure that a lot of our clients use, but we would prefer to see rules and regulations that relate to the conduct and behavior of the dog rather than the size or breed. So the next question, if a board appoints a director in order to replace a director who resigned, can the board later rescind their vote and remove the appointed director? And so my answer would be generally no. You cannot remove a board member because removal of a board member is specifically provided for at the as a decision of the owners generally. There's an exception to what the board can do written in the statute to allow for the appointment of board members. It does not provide for the removal of a board member. We have a lot of clients that confuse the provision in the statute, and it is in UKIOA, it's in 649520, that says the board may remove an officer. Officers are the individual named positions like president, secretary, treasurer. And it is true that the board at any time can change who the president, secretary, and treasurer are. but that does not remove them from the board. You can take the president out of his position as president, but he's still a board member, still gets to attend meetings, still gets to vote. And the vote of the president is the same as the vote for any other board member. There's no difference in the voting power when decisions are actually made. So I would advise that in almost all circumstances that you cannot remove a board member that was appointed. I could imagine there might be some circumstances where that would be different if the board member was not qualified to serve, or if there was some other special circumstance, but I'd need to see your documents and know the circumstances to give a different answer. Did you have anything on that, Tima?
No, I do not. I think that covers it. The next question we have is, can a consultant draft a construction contract for us to use with a roofing contractor? The short answer is yes. The longer and more detailed recommendation that we would, the nuance we would suggest here is that a consultant that is drafting a construction contract has a certain set of objectives. And we as attorneys would say, if you are going to engage in a contract with a consultant, that you also bring your attorney in to look at other aspects of the contract. So a consultant is going to look at the scope of the work, the time frame for the work, materials, other types of details related to the construction itself. An attorney, your association attorney, is looking for all of the what ifs, all the things that might go wrong with that construction, with the construction itself, and any types of loopholes in the contract that would leave the association vulnerable. So we would want to look at payment options and payment issues, any type of dispute regarding the scope of the work, the quality of the work. So the bottom line is that you really want to have your association attorney look at that contract before you sign it. Let me see. Yeah, and there's other things like waivers of liability that construction contracts often have woven in there, that an association attorney would be able to look at and understand what type of risks are being shifted to the association. And we would have the ability to make some edits and changes to that contract to protect the association. Ken, did you have, I know you do a lot of this yourself. Do you have any, I'm sure you have some additions.
Well, certainly a strong recommendation is, if you're going to spend a lot of money on a construction project, that the amount of money you're going to spend on a good attorney to review it is tiny in comparison to your project scope, and it's worth getting the protection it can provide. We had one last month where a consultant had prepared a perfectly good construction contract for a $50,000 project, but the project price was $1.25 million. And the contract was not appropriate for a project of that dollar value. And so we made a strong recommendation that they needed to modify it. There is a set of contracts through the American Institute of Architects, which we actually do use a lot because they are fairly neutral towards the contractor and the owner in their initial drafts. And we modify them to be protective of the owners. But the AIA, American Institute of Architects, has different levels of contracts. They range from 5 pages long to over 30 pages long. And depending on what kind of work you're doing, one of them may be appropriate and the other not appropriate. And so we do recommend you have a consultant to determine the scope of work and to oversee the work during the course of construction. But we think you need an attorney at the beginning of the project who understands construction work and can help you tailor a contract so that the insurance provisions, payment provisions, dispute resolution provisions are all in place, because what you don't want is to get something happening during the course of construction which stops the project because you don't have an agreement between the contractor, a consultant, and owner. Anything else, Tama?
No, thank you.
Okay, so next contract is, can an association amend their CC&Rs without using an attorney? So, the short answer is yes, they can. Developers do it. We see associations do it. And it doesn't mean they should. We frequently run into mistakes which have been made when I'll say amateurs are trying to revise CC&Rs or declarations. We had one client where, in trying to amend something simple, they actually erased all of the original covenants. They were, I think, amending a parking section. And so they revised the parking section and then wrote in at the bottom of the document that all other portions of the CC&Rs were replaced by this new single provision. And it effectively wiped out all of the original CC&Rs. And it was not the intention of the parties to do that, but they didn't understand what they were writing. We also have had a couple management companies that had written multiple parking space or storage space swaps. And they may have gotten the first one right, but then they didn't update each one as they went. And so they failed to comply with the statutory requirements that the amendments each refer to all prior amendments. And so, again, we would recommend that you engage someone who understands the process better. Anything you want to add, Dima?
No, but the next question dovetails, because the next question is, can a condo consultant draft a restatement for an association, or must it be an attorney? So, I'm not going to repeat everything Ken just said, but essentially the same answer applies. Of course, you can do whatever you want to do, but an association attorney is going to have a more specific handle on the on the specifics of what is required for drafting and properly recording a restatement. So generally, we would recommend that you consult and at least consult an association attorney, have them review it for a minimal amount to ensure that everything is drafted correctly. Ken, do you want to add anything more to that?
No, I guess we recommend that you let attorneys do the practice of law rather than people who are not attorneys.
If you're paying someone anyway, you might as well pay an attorney to do it, because they're going to be in the best position to identify any type of inaccuracies.
Okay, so the next question is, how can we find out if there's coverage under insurance policy for a specific kind of loss? And this is actually something I put in here. We had two clients in the last month that had large losses related to water, one of which was a sewer backup and one of which was a toilet overflow, which are not quite the same. And both of them had either a high deductible, or they were denied entirely by the association's insurance. And so the short answer is, you can ask your broker or whoever's selling you the insurance what kind of coverage you are getting. And you need to be specific about some kinds of losses. So you need to know if sewer backup is included in your policy or how much there is actually going to be coverage for. The longer answer is, you need to actually read the policy to see what the exclusions are written into the coverage language. So most insurance policies are what they call broad form policies. They cover any loss unless there's a specific exclusion for it. Then the insurance policy will have a long laundry list of specific exclusions. They will exclude sewer backups, or they will exclude water damage which occurs over an extended period of time. Sometimes they will define that as a 14-day period. They will exclude certain kinds of theft. They will exclude certain kinds of losses. And then they will, like flood is typically excluded. And then they'll define a flood. So if it's any water that flows over the ground before it enters the building, it's a flood and it's excluded. And then there are some kinds of limits where they will have a larger deductible so that they don't have to start paying until the losses become big, or they will put a cap on the amount of money they will pay. So we had one client where they had a $50,000 deductible for sewer backup, and then they had a $25,000 maximum payout on a sewer backup. So the client suffered a $300,000 loss and only got $25,000. The insurance agent disagreed with me when I said there was no insurance coverage, because there was $25,000 worth of coverage. But you need to be able to decipher the policy. And I think it's important when you are renewing your insurance to ask your agent about exclusions and about caps on certain kinds of coverage, and actually get a copy of the policy. I had a conversation with a board member yesterday. He sent me 15 pages of documents, which he thought was the policy, but all it was the bill for the insurance for the coming year and a list of what the insurance company calls a declaration, which says the amount of coverage for different kinds of losses. But it did not include what would have been more than 100 pages of policy language, which would include the base policy, changes for condominiums, changes for Washington State, endorsements, exclusions, and he didn't know how to get it. And so my suggestion was contact his insurance agent. They will send him a copy of the policy, but until he has a copy of the policy in my hands, I could not answer the question on whether or not there should have been coverage for a loss that the insurance company denied. Anything you want to add, Tima?
No, I mean, I think the bottom line is read the fine print, and these insurance policies have lots and lots of exceptions, and you'll definitely want to make sure you understand what those are, because it can be very confusing for us as attorneys to read them. So I'm sure they're confusing for you. The next question is, how much of RCW 6432 does Senate Bill 5796 affect, and when does it repeal it? So the question, so to answer one, I interpreted this question to ask, when does the WUCIOA for all go into effect? But we will get into some more details on this, because I think there's some other questions embedded in here, or at least I'm anticipating that. The WUCIOA for all that was approved in 2024 means that on July 1st, 2028, as of now, and it looks like it's going to happen, the WUCIOA will apply to all community associations. And that means that the WUCIOA Act will supersede all of the other statutes effective July 1, 2028. Between now and then, you are still required to follow the rules for your specific association. To back it up, in 2018, there were statutory changes that went into effect that I'm sure most of you are aware of, but it's worth mentioning here because of the nature of the question. When it comes to budgets, which I talked about earlier in my opening tutorial about collections, when it comes to budget and reserve studies, WUCIOA applies to all communities. So when you're drafting your budgets and you are ratifying your budgets, you are following the rules of WUCIOA. And so that is the case now, and it will continue to be the case. There are exceptions to everything, and without going into all of them, Ken and I were discussing one, for example, which is the CPA audit requirement. That is one that is under the Condominium Act, and under WUCIOA, they're treated differently. For example, in the Condominium Act, an association may choose to waive an audit if they have less than 50 units. Under WUCIOA, you may choose to waive the audit requirement if it is less than $50,000. So there are different requirements. And it's worth noting that the Condominium Act, when it comes to the CPA audit requirement, applies to old act condominiums, which is what this question is about. So the bottom line is, if you have questions or you're confused about what exactly applies to your condo, to your association now, you should reach out to your association attorney if you're not sure, because there are certain requirements that apply to all associations, and then there are certain requirements that are different. And I can't get into all of them here, but in between now and July 1, 2028, you need to remain aware of what those differences are. Ken, did I cover all of that?
I think you did. I mean, the
Okay.
purpose of uKiowa for all was to try and eliminate the confusion about which statutory provisions applied to which communities. And I don't know why they changed it to 2028 for its implementation when they adopted it last year, but that's what happened. And then you should be aware that there are at least 15 or 20 other parts of uKiowa which the legislature is looking at right now and may become applicable retroactively to the earlier statutes ahead of 2028. Because there's a faction of owners who are lobbying with the legislature to either move up the date for uKiowa for all or make these other sections apply.
Yes.
Okay. So next question, when updating an association's rules and regulations, I understand the steps to be: 1, develop the new rules; 2, the board approves the new rules in a meeting; 3, the new rules are sent to the owners; and then 4, 30 days later, the new rules are enforceable. So my question is, where in the process is a meeting to discuss or answer questions about the new or modified rules best scheduled? If it's too near the beginning of the 30 days, many homeowners may not have had time to review. If it's at the end of the 30 days, changes the board may feel unnecessary, would not have time to start. So the answer is going to be different if you were a uKiowa community or if you were under one of the previous statutes. Under uKiowa, the process requires an additional step. It requires that the proposed rules be sent to the owners for review before the board can make a decision. So you'd have to send the rules out as proposed by the board, have an opportunity for the owners to comment, then the board would have a vote to adopt the new rules. And then the 30 days is not fixed in the statute. You would make the rules applicable in some reasonable amount of time. It might be a short period of time, it might be a long period of time. So if you're looking for input from owners on the boards, either because you just want it under the current statute you're under, or you're required to provide it under uKiowa, I'd say 30 days seems like a reasonable amount of time, even though the statute does not fix a time. So if you were at one monthly board meeting as a board to decide you wanted a rule about allowing dogs over 35 pounds, you could then mail it out to your owners and say, we are proposing a new rule for 35-pound dogs, and we're going to vote on it at our next board meeting. And then the owners would have a chance to send emails or show up at the board meeting and give their comments about the new proposed rule. The board could modify the rule during the next board meeting and adopt the rule at that board meeting. And it would be enforceable after they've distributed the new rule to all the owners and given some reasonable time for enforcement to start. So did you have any other thoughts on that, Tima?
No, and I agree with what you're saying here. I mean, essentially, you can set your own time frame for the review period. And like Ken said, 30 days is reasonable. If one thing to take into consideration is the time it takes to mail things and when it's being received. We usually want to give at least a week for mail these days. So that's just another consideration if you're mailing something to the ownership in advance. The next question is, if a unit owner has installed a camera in a common hallway and that tracks movement as people walk through, could this be considered an invasion of privacy? Or does the fact that it's a common area mean that there is no privacy concern? So the short answer to this question is there is no expectation of privacy in a hallway. A hallway is considered a public common space. So full stop. That being said, the community is permitted to prohibit anything in a common area. So if the ownership doesn't want cameras in the common area, that can be prohibited. If there are going to be cameras in the common area, whether they're to track movement or for safety reasons or for whatever purpose they're there, we always just inform the ownership that this is what's taking place and that you are installing cameras, and give them a notice about this and when you're installing them and when they'll be installed. The same way that we recommend that you notify the ownership of anything taking place in common areas. Ken made the point when we were discussing earlier, if an owner wants to put a camera, so if there's a prohibition on cameras in the hallway, but an owner has a window that faces the hallway and they have a camera installed within their unit, that can't be prohibited. So, you know, there can be exceptions but the answer to the question is there is no expectation of privacy in a hallway. Ken, do you have further comment?
We have had this issue come up fairly often, and we do think that it's reasonable to adopt policies which are balancing the safety and security concerns against the privacy concerns. We have some clients that have adopted policies regarding ring cameras and the new kinds of locks which can go on a door where a person can remotely unlock the door to allow a vendor to enter their unit or a neighbor to enter their unit. And so I don't like to give blanket statements. It is going to depend on how it's used. I can also say that if the purpose of the camera is to stalk somebody, then there may be reasons to actually have have a court help you remove the camera. But that's an unlikely circumstance in most cases. Number 14, if we decide to change our HOA attorney, do we need to review our current contract to confirm whether we're obligated to use only that attorney, or is it uncommon for HOA contracts to restrict us from hiring a different attorney? Okay. So I'll offer that under the rules of professional conduct for attorneys, the client can always choose what attorney they use. And so there is nothing, you can't have a contract with an attorney that prohibits you from changing to a new attorney. I would say it's unusual to have a contract where the attorney is going to try and do that. You may have an agreement with an attorney that specifies how you will be paid. So if you had a contingent fee with an attorney to pursue an insurance claim or a construction defect claim, and the attorney is doing it based on that future payout, and you fire them halfway through, you're going to have still some obligation to pay the attorney. I don't know what it is. It might be written in the contract. It might be a sort of an equitable or fairness argument. And there are court cases that have addressed that before. But I would be surprised if most attorneys would be challenging your ability to switch to a different counsel. And the only other thing I would offer, though, is that if you are using a collections agency to do work for you, which may or may not include some legal work, many of those have very steep penalties written into the contract that if you take the collections work away from them, you are obligated to pay them what they could have earned if they had actually collected the money. And so this is one of the reasons I really dislike collections contracts with collections agencies, is because a lot of our clients will look at it and say, well, we don't have to pay anything unless they recover. But then they find that the collections matters are sitting unattended to for months or years, and they cannot take them back from the collections agency without either a fight or a payment to the collections agency. Did you want to add anything on that, Tima?
I would just say, as a collection attorney, from a practical standpoint, these things happen. Clients make decisions to move their files to other attorneys. It's something that we receive new files, we transfer files. I would say that the most important thing for me when I'm receiving a new file is the communication with prior counsel. Make sure that you are requesting, make sure that you're effectuating that change in a timely manner. If you have collections files that are in any type of urgent, timely situation, make sure you make that clear, and so that the files get transferred efficiently, and so that no steps are missed in that process. That would be my only advice. Let's
I would say
see.
if you're using attorneys who are typically serving homeowner association clients, that they are, for the most part, fairly collegial and cooperative. I'm not aware of problems. Occasionally we've had an attorney who is not really part of the group that will not understand their obligations to transfer files, but that's something usually your new attorney would help you with solving a problem about transferring rather than the old one.
Yeah, that's a good point. But in general, it's a very collegiate thing, and we work very cooperatively with new counsel in terms of providing them with whatever they need. And that's considered, that's our ethical and practical obligation to our clients. It's not used to serve them even in the event of a transfer.
So Chelsea, we probably have time for one question if you want to pick one out of the chat.
Okay. If time permits, assuming the governing documents are silent to the board member qualifications, except for ownership, can qualifications be added to the rules and regulations or implemented via board resolution? Or do the bylaws need to be appended with a vote of the membership?
I would say that you need to amend the bylaws however they are allowed to be amended, because some bylaws can be revised by the board of directors alone. And so you'd want to check what the amendment provision is in the bylaws. You might also want to look at the articles of incorporation, which are a higher authority than the bylaws, and see if there's any qualifications in that document. So maybe we can do two questions.
Okay. Rules and regulations can be amended by the board. As a matter of course, we survey owners, non-binding, before considering any changes that impact our shared living environment, and then have the proposed revisions reviewed by an attorney. Our current rules limit weight to 35 pounds. Okay, this looks like it's going back to the dog questions. We're considering going out to the owners with a rule change proposal to replace the limit with a CGC certification requirement. That sounds like it's mostly just commenting on
It's the same question. I think if you want more advice on that one, you're going to need to talk to an attorney specifically.
I'm sure we could help with drafting something specific and an association attorney could do that, and to confirm that it's proper procedure and read that over. Sure.
Do you want me to go with one more?
Sure, try one more.
Okay. Is there a difference between routine monthly assessments and special assessments in terms of recovery of overdue payments? For monthlies, for example, there are requirements such as the need to wait for 3 delinquencies in a row or within the last 5 due dates. Can you proceed with collection of special assessments as soon as the first due date is missed?
Yes. So when we draft when we take your management ledgers and like I went through in the beginning, all of the procedures that we follow as far as the intake process, we will look at, and I say yes, assuming that your special assessment was properly drafted and ratified, the same way that your regular budget must be properly drafted and ratified. Assuming that those things took place, a special assessment is not treated differently than a regular assessment for collection purposes. You know, and again, special assessments are sometimes, there's different ways that special assessments are applied in a ledger. So sometimes they're applied as a lump sum payment with a due date of, they'll say, the governing documents might say the special assessment is due by December 31st, 2025. And that's the date. If it's not paid by then, it's applied to the ledger. Other times it's spread out over monthly payments. So it's going to depend on exactly how the special assessment was structured, that it was properly drafted and ratified. But to answer the question, the short answer is no, there is no difference between the special assessment and regular assessment from a collection standpoint. Ken, did you have any comment on that?
I'll just offer, in some cases, like if you have a large special assessment and a bank loan financing a project, and you have in the terms of the bank loan agreement that you have to keep delinquencies under a certain amount, then you have pressure to start the collections process almost immediately if an owner does not pay on time. We have one client where they're looking at a default interest rate on their loan of 18% because they have more than 10% of the owners delinquent on payment of the special assessment. And that will more than double the payment obligation each month for the association. So they need to take very aggressive collections actions and make sure they stay within the allowed delinquency under their loan.
Good
But
point.
with that, I think we are out of time. So thank you, everybody, and we
Thank
will
you.
see you next week.